Thanks everyone for joining. So today's event is the IDEA Symposium on Race and Intellectual Property, hosted by IDEA, the law review of the Franklin Pierce Center for Intellectual Property. IDEA is a top-ranked intellectual property law journal. Our team of student editors publishes 3 issues a year on various topics relating to trademarks, copyrights, patents, and unfair competition. The journal is over 60 years old, making it one of the longest-running IP journals in the country. I'm Haley Breedlove, the symposium coordinator and a member of the editorial board. First, I want to say thank you to everyone that helped us make this event and find all these amazing authors, especially Professor Ann Bartow, Professor Kavicki. For those unfamiliar with the law review symposium process, this event is a chance for a group of authors to present on various legal topics. Then they'll write full articles, which the law review publishes. For today's symposium, the topic is the intersection of race and intellectual property law. We have selected 5 authors to give brief presentations on their topics pertaining to race and IP. Then these authors will have their articles published in IDEA Volume 61, Issue 3. Today, there will be 5 10 to 15-minute presentations, followed by a brief Q&A. If you have questions, please post them in the chat box and I can ask them to the presenters following their presentation. So first up, we have Dr. Elizabeth Townsend Gard and Whitney Chatmon. And they'll be presenting the fabric of racism, IP in the quilting and fashion industries. I'll have you guys go ahead and pull up your presentations. So Dr. Townsend Gard is a professor of law at Tulane University with a PhD in cultural history from UCLA. She is the host of Just Wanna Quilt, a popular podcast on quilting and copyright, and is the owner of Quilting Army Crew, an experimental entrepreneur quilt shop. She teaches IP nationally at quilt shows and has written Just Wanna Trademark and Just Wanna Create, copyright and fair use strategies, using examples in both books and from the quilting world. She spent the spring 2021 making masks and organized with Whitney Chatmon the Homemade Mask Summit, a 2-day, 10-hour event bringing suists and scientists together. Whitney Chatmon, originally from Maryland, graduated from the University of Maryland flagship campus, double majoring in government and history with focuses on Black women and human sexuality. She's now a 2L JD candidate at Tulane University. She's on the Tulane Journal of Law and Sexuality and the student chair of the Institute Equity Committee. Her interests in courses fall under intellectual property and employment law. Sorry, I'll let them go ahead and get started.
Thank you so much for inviting us and having us part of this. We're very excited. Whitney, I think you begin.
I do. Okay, so our paper in great part focuses, or let me just tell you, the fabric of racism, IP in fabric industries and communities. Our paper in great part focuses on the dress in Michelle Obama's portrait. From 2018 in the National Portrait Gallery. It is striking for a number of reasons. One report from Kimberly Chisholm Campbell titled "The Hidden Political Message of Michelle Obama's Portrait Dress: From the Pattern to the Designer, the dress is the most revealing part," and we agree.
So what we were going to do today is look a little bit about why this dress is so such an interesting place to get us into this question. We're going to be looking at the quilting industry and the fashion industry. We're going to focus mostly on sort of the cultural aspects of what we are finding. You as a intellectual property community will also be able to see some of the intellectual property issues that are arising. But we wanted to give you a little more of the cultural background and the spaces.
So what is the hidden political message behind the dress? We find 2 layers, a quilting message and also a fashion message.
Okay. So Kimberly Chrisman Campbell is a reporter, and she wrote that article that we had talked about before, The Hidden Political Message of Michelle Obama's Dress. And what she was, she's kind of an interesting starting point. When the dress came out, I instantly as a quilter knew what this dress was in terms of the pattern. And she really pushed it in interesting directions. And so for this symposium, I talked to Whitney, and we both kind of agreed that it was an interesting space to explore. So let's first take a look at the dress. This is the dress. And I imagine that many of you have seen this portrait. And I'm curious, and I don't think there's any way to know because it's hard. I don't know what abilities we have on Zoom. If I was with you, I would say, raise your hands. How many of you know what this is? From my perspective, it is an homage to a group called Gee's Bend, which is a super famous African-American group. They were fairly poor, isolated. A white male art collector came through, found them. They became a big thing in Whitney Museum and all over the world. And almost every museum has had their quilts. And so here's this. See that? That makes sense, right? You see that in the dress. And then here's other things. And so this designer took the Gee's Bend, see the circle, see the bars and the triangles. Well, these are common aspects in quilting. It is really specific to Gee's Bend. And so the dress itself was paying homage to a specific subset of quilters and this genre of quilting that is very 20th century quilting. And so that got me sort of thinking about why Gee's Bend? Gee's Bend is one thing that just everybody knows, and everybody sort of, if you're going to talk about African-American quilting, it's going to be about Gee's Bend. And so we hear from our local quilters here that are African-American descent, well, we were doing that too, or it's not that exciting, or there's other ways, or African-American quilters do all kinds of quilting, don't pigeonhole us. And so this really was a question of sort of what place does Gee's Bend play in the history of quilting and African-American quilting, and also in the quilting industry. So we have other key African-American quilters. Harriet Powers, 19th century quilters, really, really, really famous. That's what was How to Make an American Quilt is based on her work. That's this quilt, that's this one right here. This is the one in the movie, and there's litigation over it. We also see, so here's the litigation, and we will talk more about that in our paper. There's also another case, Faith Ringgold, who's super, super, super famous African-American quilter, does collage quilting, where HBO in one of their series uses a poster of hers without permission, and the court says it is not a de minimis use. And so we get a little bit of that. We also get sort of, when we think about who are our quilters, Shawn Kimber is super, super famous. She's a professor of math at a college, but she's also a really, really famous quilter, super famous. So famous that when there was a exhibit in Atlanta, we drove to Atlanta to see it because it was so important to go see her work. And she does a lot of protest quilting, a lot on the Black Lives Matter movement, and she's really an important thing. Ebony Love is another really prominent African-American quilter in the quilting industry. She's an entrepreneur. She's been an ambassador for different programs. She is probably the most well-known African-American teacher of quilting at this point, and she's part of our study as well.
Dr. Townsend, Gard, do you want to go ahead and hit present, because some of the images are just a little hard to see.
Sure. Can you still see it?
Yeah.
Okay, good. I didn't know if it, okay, cool. All right, so but the industry itself seems fairly unenlightened, and this is a bit of the problem. Can you see this now? Can you see that?
Yeah.
Okay, so the Quilts Inc. is one of the major quilting show producers. This show usually, when it's not COVID, has 50,000 people attend it. This is the virtual quilt festival during 2020 when Black Lives Matter and race is an issue. Look at their lineup of people. There are 42 teachers, and they are all white and mostly women. So that's not great. Let's look at this one. So Aurifil is a thread company. They had a huge problem with this a few years ago, where they put out a list of their new artisans, which are ambassadors, and there was no people of color at all. They have done a little bit better, a little bit, but not that much, right? And then Island Batik. Ebony was an Island Batik ambassador, but she's not now, but look again. So a little bit of color, just a little bit, but certainly not much. And so, so that to me is fairly problematic. We see that the fabric that they make, that the industry makes, often, like if it has children on it, have only white children on it. We see that I have a group, Just Want to Quilt, as part of the podcast, and we have a lot of different people and people of color, and we got a comment, oh, I didn't know Black people quilted. We have a local group here in town in New Orleans that's called Cotton Pickin', without any irony, and it's all white women. So finally, I would say that the Black Lives Matter, it was really a problem with the group, with the quilting groups online. Some of them embraced it wholeheartedly. Cheryl Sloboda, others were really supportive. But there were a lot of companies who even called me to talk about it, to ask privately, and groups that were too afraid to put something out for fear of offending their white clientele. So while we have a lot of prominent African-American people and the work and it's part of the history, we still have an incredibly segregated and also a very lopsided vision of what the industry is. And so we're going to be doing more interviews on that side of it. So that's what I learned from Michelle Obama's dress. I'm going to turn it over to Whitney for the next part.
Yeah, so we're gonna still be looking at, or say our center focus is still going to be Michelle Obama's quilt dress. It was made by Millie, which is a company that prides itself in creating from a strong female point of view, challenging ideas of femininity and classic American sportswear. Michelle Obama commissioned the brand to design the dress for her 2018 national portrait, but we want to know why. She often wore Millie designs, so what statement does it make for the former First Lady to wear a brand that is often sold in department stores? And we can move on to the next slide.
Do you want me to keep going?
Yeah, we can skip this one and the next one. And so what we're going to be considering is this with why Michelle Obama went with the Millie brand, and alongside the role that models play in discriminatory practices of the fashion industry. We see that models, an often exclusive and non-diverse group, represent a brand's image. Diverse models are often not chosen. As a model's look is what represents a brand, do they have any property right to their person in the representation, or are they truly just a blank canvas? And here I have the example to consider, which is Iman in the People magazine Millennium issue. The photographer thought that her red curly afro was a wig as a prank and was really like, okay, haha, remove it. After just a couple pictures, and she revealed that it wasn't a wig, Iman wanted to represent curly hair to young Black girls at the turn of the millennium, and it became an iconic statement, and honestly, the statement of the shoot. And does she have any property right to this shoot and the statement of celebrating diversity? And alongside this, should Michelle Obama have any property right over her publicity and popularizing the Millie brand? And we can move on to the next slide. We also want to look and consider gender and sexual minorities as models regarding when and how they're used and represented within the industry. Next. Next to discover for us is who has a seat at the table, with an understanding that when designs are made, someone approves them. We want to know more about who approves and who gets to share ideas. The idea is that if labels had a diverse group of designers and decision makers, someone would have raised concern regarding the racist, albeit unintentionally racist designs. And here we see even Gucci in the past couple of years has released these blackface designs, and most people don't really think that it's a intentional blackface design, but if they had a diverse team, someone would have raised this issue that, hey, this can be perceived as blackface. Even Millie's founders, Michelle Smith and Andrew Oshrin, they were a couple at the time, are non-diverse. Michelle Smith is a white woman and was the designer for the brand from 2000 to 2019. And she does now identify as a member of the LGBTQ plus community, however, and that is represented in the models and her brand. Next. Lastly, in fashion, we'll be looking at cultural appropriation. How do we measure cultural currency and how does it translate economically? Since copyright is a right upon inception and creation, we need to determine how to assign the property right when the infringement is against the creative expression of an entire marginalized group. The right to distribute and make money off of their creation has been stolen. Yet personhood theory also tells us that damages for any infringement in this instance would likely be that of a group's personal value, depending on the meaning of the stolen work. And so can a fashion brand monetize off of a minority group's personhood? This is the trend that we've been seeing through all of our research, which is why Millie and the portrait gown have become the centering piece of what we keep coming back to. A white designer appropriating G's Bend and gaining notoriety from it, and a Black woman in the National Portrait Gallery. Next. And so our next steps in our research are continuing going through interviewing people in the industry, in both the quilting and fashion industry. And that's something that really brought up this topic for us, because with our Homemade Mask Summit, we were talking to people all over, and it wasn't just quiltists and sewists. We were talking to people on Broadway and costume designers and people who work on film sets, who are all working together to make masks. However, with the political climate and the social unrest and the murders of George Floyd and Breonna Taylor all overlapping with this, our conversation shifted to how discrimination and IP overlap in all of our fields.
And so what we'll be doing over the next few months is doing interviews both in the quilting and the fashion industry to really understand sort of how aware they are of the issues that are arising and how much they aren't aware. So I think it'll be a really interesting journey, and we're hoping to do between 30 and 50 interviews over the next, say, 4 to 6 weeks. And that's where we are.
Awesome, thank you so much. And did anyone have any questions that they wanted to post in the chat for this presentation? I saw that we had to remove some people from the chat. I apologize for that. We made it so that you had to have your name to post questions, so that shouldn't be a problem anymore. All right, I'll move on to our next presentation by Willajeanne McLean. Who Are You Wearing? Avatars, Blackface, and the Commodification. Professor McLean has been a member of the UConn Law faculty since 1991 and has taught trademark law, torts, and institutions of the European Union, and a seminar on intellectual property law in the EU. She was a Fulbright Fellow at Adam University in Poznan, Poland, where she taught comparative EU and US intellectual property law and lectured at the Intellectual Property Law Institute University in Krakow. More recently, she gave a series of lectures on comparative intellectual property issues at Beijing Normal University in Beijing, China. Her research interests include the interface of intellectual property, popular culture, and European law. Great, thanks. Professor McLean, can you make sure your mute is not on? Professor McLean, we can see.
I'm unmuted.
Okay.
Now I have to go back to share screen. I will be there momentarily. Sorry about that. Can you see now?
Yes, we can.
All right. The title of this is Who Are You Wearing? Avatars, Blackface, and the Commodification of the Other. The question, who are you wearing, is asked frequently on the red carpet for the Golden Globes, the Oscars, and the Emmys. The question was first asked by Joan Rivers in 1994, and it generally elicits the name of the designer of the gown or the purveyor of the jewels worn by the actresses as they arrive at the awards venue. What I seek to do in this paper is to upend that question by applying it to the use of avatars, blackface, and the bodily appropriation of others to interrogate the use of technology and intellectual property in maintaining the power of the dominant red-white culture. So in an old New Yorker cartoon, which depicts two dogs, which you can see to the left of the screen, talking to each other, one dog exclaims to the other that on the interwebnet, nobody knows you're a dog. This concept applies to humans as well. The internet and video gaming open up worlds of possibilities regarding one's persona. Imagine that someone short, black, and chubby with awesome glasses could transform herself on the web into the slightly taller, willowy Angela Bassett version she always wanted to be, or she could become a cat. Thus, the internet allows for the reinvention of self. But the question is, whose self? In general, however, people of color do not have equal access to play accurate self-representation, since most of the avatars that one can choose in a game are by default white because of a lack of minority representation. This lack of representation leads to what one scholar calls the presence of absence. That is, the underrepresentation of minority characters functions to reinforce whiteness and the idea of the other, where people, white people, interact with racial minorities who are driven by aspects of their collective nature. Therefore, the players are left playing within the confines of stereotypical tropes attached to bodies of colors, such as athletes, thugs, or prostitutes. In addition, when people of color do have access, they may not be able to generate avatars that resemble themselves and end up passing for white because the skins and the feature of the avatar are just darkened, a virtual blackface, if you will. Which led me to think about blackface. The beginnings of blackface are rooted in the 1800s when white actors blacked their faces to represent their take on African American life. Although one could argue that minstrelsy has, at least in its 19th century form, disappeared, the use of blackface has not diminished over time. Certainly, this has been borne out with the recent spate of elected officials shown in deeply disturbing photographs. One of my colleagues, Thomas Marowitz, in his book, Making Faces, Playing God, wrote about disguise and masks And he says, one ceases to be recognizable and suspends personal responsibility without the difficulty and drawbacks of being incorporeal. And certainly personal responsibility is abrogated. The excuses that one is or is not the person pictured, or that it was done in fun, ring hollow. Politicians are not the only bad actors. Another salient example of the use of blackface is that of Rachel Dolezal, who, according to one commentator, used blackface to experience blackness, avoid white responsibility, and co-opt it to authenticate herself and her work. Unfortunately, Robin Givens, a Washington Post columnist, has said that blackface has been modernized and the internet has weaponized it. Recent literature points to at least two phenomena of blackface in the internet age. There is this trend known as digital blackface. According to Lauren Jackson, it uses the relative anonymity of online identity to embody blackness. As we all know, memes and images go viral on the internet, and those containing Black people are more prone to circulate widely. Ms. Jackson commented that Black people and Black images are relied upon to perform a huge amount of emotional labor online on behalf of non-Black users. We are your sass, your nonchalance, your fury, your delight, and she ends, your yes moments. Many who write about digital blackface reflect on the harm that it does, that it helps reinforce an insidious dehumanization of Black people by adding a visual component to the concept of the single story. According to Chimamanda Adichie, the single story, and I'm quoting, creates stereotypes. And the problem with stereotypes is not that they aren't true, but they are incomplete. They make one story become the only story, end quote. And this certainly becomes true when the only experience of the other is through the lens of a gaze that fixes its subject and cuts away slices of that person's reality, as discussed by Frantz Fanon. So another type of blackface occurs in video games. Adam Clayton Powell referred to such stereotyping as high-tech blackface, observing that any game has a certain stereotype, negative or positive, but a computer game is going to pass that message along pretty powerfully. Ruha Benjamin, in her new book, Race After Technology, says that much more is at stake than just fun and games. Quoting Dr. Fox Harrell, who said, prejudice, bias, stereotyping, and stigma are built not only into many games, but other forms of identity representations in social networks, virtual worlds, and more. These have real world effects on how we see ourselves and each other. Another study talking about avatars and video gaming that conform to racial stereotypes has found that they intensify prejudicial attitudes, and that this may be, as Nakamura says in the quote that I have accompanying this slide, because users don't just consume images of race when they play video games, they perform them. So as expressed by Naomi Day, the trend of blackface is another way that Black bodies are consumed by non-Black people in a harmful and stereotype forming matter. And so I move to the question of blackface as fashion. And Robin Given, who I mentioned earlier, basically says that blackface isn't a fad or one-off. It's a classic that's embedded in the cultural vocabulary, reimagined, modernized, stylized. And here are several examples of blackface showing up in fashion. The use of Little Black Sambo, even though he's supposed to be a penguin. Prada Malia that came out with these little charms that are supposed to be imaginary creatures. But if you look at a picture of Al Jolson in blackface and look at the images, one is struck by the similarities. Gucci, you have already seen. This was highly problematic to say the least. Katy Perry, as you've already seen, who said that her intention was never to inflict any pain. So you have the question of cultural appropriation and commodification of the body. And Bell Hooks wrote about it and said that when race and ethnicity become commodified as resources for pleasure, the culture of specific groups as well as the bodies of individual can be seen as constituting an alternative playground where members of dominating races affirm their power over in intimate relations with the other. And as an example of cultural appropriation, I give you Kim Kardashian West, who wanted to get a trademark for kimono solution wear for ladies' underwear. And you can see the hashtag Kim Oh No. It created quite a furor because traditional kimonos tend not to involve lingerie. And while there are other trademarks using kimono, none were to women's clothing. And so she withdrew, she abandoned her trademark. When you continue to think about commodification, certainly one has, as the, shall I say, poster person for commodification of the other, one has Aunt Jemima, who has been used for 130 years as the brand spokesperson for pancake mix and syrup. And characterized by a commentator, they said that Aunt Jemima, Rastus, Uncle Ben, they were always clean, ready to serve with a crisp smile, intuitively knowledgeable, distinctively Southern in their spoken words, and epitomize servility with exceptionally natural cheerfulness. I'm not going to say much more about Aunt Jemima because I think one of the other speakers will, but I want to come back to the question, who are you wearing? And here you have a designer who decided that she would answer the question, who are you wearing, by creating a clothing line using the nude body of Oprah. And what she said was, one of Oprah's most effective qualities is that she is a placeholder, a stand-in for you. And there's one Oprah thin, one Oprah chubby, one Oprah normal, slender, and one wearing a kiss mask. And so, the question is Oprah a blank canvas on which others can project? It is reminiscent of the use of human skin to cover books, or just as creepily, the character in Silence of the Lambs. And so when you think about commodification of bodies of color, you have Noland saying, I'm sure Oprah wouldn't be excited about it, but it's an interesting conversation to have. And so what she's essentially saying is that Oprah's feelings about the matter are irrelevant because it's all about access and interest in people we don't know. I want to end here. I've used avatars and Blackface and commodification to show that technology can be pernicious. However, technology can be used to change the imagery that so often a part of our daily lives. Use of Instagram led to Prada's apologies, but also to the decision to put in a staff through racial equity training to create scholarships and a paid internship. Outrage and social activists forced the hands of CEOs of major food companies to end the servitude of their brand mascots, such as Aunt Jemima and Uncle Ben. Ironically, these changes occurred without the force of trademark law. Here, I mean the now defunct disparagement clause of Section 2A. And I want to emphasize that every borrowing is not a misappropriation. However, it is necessary to think through the ramifications of branding and creating intellectual properties. I think the suggestions that are here offered by Kenneth Shelton and those that are offered by Professor Scafidi, inviting those who are involved in creative practices to think about source. Is it a group that has experienced oppression? Significance? Does it have importance within the culture? And similarity? Is this a line-to-line copy or inspiration? Are things that we should think about when thinking about the use of others. Thank you.
Thank you so much. Awesome. Does anyone have any questions? Want to post in the chat or in the Q&A? Let us know. I'll wait a couple seconds for that if anyone has anything. All right, I guess if no one has any questions, we'll move on to our next presentation. Thanks again, Professor McLean. Our third presentation is Dr. Anjali Vats talking about temporality in the time of TAM toward a chronopolitics of intellectual property law. Anjali Vats is an associate professor of communication and African diaspora studies at Boston College, and an associate professor of law at Boston College Law School. She's interested in issues related to race, rhetoric, law, and popular culture, with particular focus on intellectual property law. Her forthcoming book, The Color of Creatorship, Intellectual Property, Race, and the Making of Americans, published in 2000, examines the historical and contemporary relationships between copyright, patent, and trademark law and race. Vats has published in a number of law journals and intellectual property law journals. In 2017, as a postdoctoral fellow, Vats taught at UC Davis School of Law. She was previously a faculty member in the Department of Communication and Culture at Indiana University and affiliate faculty member in the Center for Intellectual Property Research at the Maurer School of Law. She also served as a law clerk to Chief Justice A. William Maupin of the Supreme Court of Nevada. And Professor Vats, I'll let you go ahead. Thanks.
Thanks so much. Let me just get my slides up here. Okay, so I am delighted to be here tonight, and I appreciate all of you being here as well, because I know there is exciting stuff going on in the world. So thank you for being here and indulging these conversations tonight. I want to talk to you about a new project that I am working on. It's called Temporality in the Time of TAM, theorizing chronopolitics in IP litigation. So this is a project that is really getting into the weeds in ways that the book that I just published doesn't quite do. So I want to shift gears, and I would love any feedback or questions or thoughts that you might have about some of these issues that I'm raising here, because this is a project in the very early stages. So I want to start with this question: what is chronopolitics, and what does it refer to? Before I get there, I want to back up a little bit and tell you about the work that I've done in the past. This book that I have been working on for 10 years just came out, and it is a history of race and intellectual property. And it really develops this idea of critical race intellectual property as a project of identifying where whiteness is really centered and protected within the context of intellectual property law. One of the things that I want to emphasize is that can really involve a number of approaches. So while critical race theory often tells us that we are looking for racial non-neutrality in the context of law, it doesn't necessarily tell us how to do that. And one of the things that came up for me when I was writing this book was methodologically how I might approach these questions. So that's a thing I'm really playing with in the project I want to talk about today. So here I want to move from this big picture approach of looking at what the book talks about as intellectual property citizenship and looking at racial scripts to looking at the technical procedural questions that arise in intellectual property cases, really over a 20-year span instead of a 200-year span. And I'm really looking at two cases. So I want to raise this question of what critical race theory can offer in terms of thinking about methodology, but also what other complementary fields like Black studies and ethnic studies, which heavily influence critical race theory, and kind of have this back and forth conversation with critical race theory, what they have to offer here, and what we might think about in terms of those lenses as well. So on that note, let me shift to this question of chronopolitics and what is chronopolitics. So chronopolitics originated as a term for thinking about the politics of time. And what do I mean when I talk about the politics of time? Well, I'm talking about the way that time operates in the world, because the ways that we talk about time and structure time are not necessarily those aren't necessarily neutral, right? So certain people have access to more time than other people. I think this election is a good example of that. If we think about divisions of labor, if we think about temporality, if we think about when and where things happen, we have been waiting, right, for a very long time, but not a long time at all. So we can see quite literally playing out on national television a politics of time. So what does the politics of time have to do with race? Well, Black studies theorists take up time in many contexts, but one, I think, good one to kind of exemplify what we're getting at here is the context of Afrofuturism, of speculative fiction. So what is speculative fiction about? Well, it's about locating future times, and it is also about thinking about how we might play with time. So I want to highlight that as an example of a direction that chronopolitics can take. And also, I think that Afrofuturism is having a moment right now, really a really important moment. So if we think about works like Black Panther, if we think about N.K. Jemisin, other folks that are thinking about time, there's really, I think, a lot of value in interrogating how this works in the context of intellectual property law. So here's some examples of folks that take up questions of time, right? We can go back as far as Sun Ra. We could go even further back than that, but I've chosen that as a kind of benchmark for thinking about Afrofuturism. We might think about folks like Octavia Butler, Janelle Monáe, Sarah Sharma, Alondra Nelson, and Charles Mills, and as they play with time in different ways, and they play with racial representation and racial reimaginings in the context of time. So why chronopolitics? Well, chronopolitics can actually help us to understand the racial effects of time. And what does that mean? Well, it means that time not only has political implications, but it has racial implications. And linear time, in the way that we seem to manage it, is a particularly European context. So if we were to think about cultural conceptions, differential cultural conceptions of time, they might look different, and they might force us to think about the world in different ways. What I want to highlight here is that time is a tool, can be a tool of racial inequality. So here are some examples of that, right? We might think about who has control over time. We might think about who has leisure time. We might think about who has labor time versus emotional labor time. Let's take this middle example, who has leisure time, and we can think about the American South. That question of leisure time is really one that is, I think, racially loaded, because how does the antebellum South produce leisure time? Well, it produces leisure time by taking time away from enslaved persons. It is white people's leisure time is structured through the refusal of racial time or of leisure time for people that have no control over their labor. And so I think this is a way of a lens for thinking about intellectual property. So I wanted to make sure you got some pictures in here. So here's Sun Ra. We can think about what sorts of invocations and suggestions he's making here about time. Of course, Octavia Butler and Janelle Monáe are folks that we might think about when we think about racial time. So let me go through very quickly here the procedural history of the two cases that I want to look at here. The first involves that Washington football team, and this is, of course, a case that stretches back very, very far. So in 1990, we had Petitioner Harjo that asked the USPTO to cancel 6 trademarks, including one for a certain Washington football name starting with the letter R. And it took until 1999 for the USPTO to cancel that trademark. But then in 2005, the district court reversed the USPTO on the basis of a lack of disparagement and recalled that these are Section 2A of the Lanham Act cases, and also on a claim of laches. And so I want to raise this question of laches as a question of time and temporality. In 2009, the Supreme Court declined to grant cert in that case. And then in 2014, when Amanda Blackhorse started this case again, the Trademark Trial and Appeal Board canceled the trademark. Now, that would be the end of the story, if not for the fact that there was another intervening case, which is the precursor to Brunetti and really sets the stage for thinking about how there's an interplay here, not only of racial dynamics, but also of time more generally. So let's start in 2010 when the band called the Slants sought a trademark registration. In 2011, the Slants, after being rejected because the USPTO told them that their name was disparaging to Asian Americans, even though they were all Asian American, tries a second time to register their trademark. In 2015, TAM files suit in federal circuit court. And the circuit court raises an issue sua sponte. It asks for briefing on the constitutionality of Section 2A of the Lanham Act under the First Amendment and ultimately finds for TAM. In 2017, SCOTUS affirms that decision. So I want to spend the last couple of minutes here talking about what this means. What are the questions of time that these cases raise? So let me talk about Harjo and Black Horse. The first question I want to raise is what laches is all about. So laches is arguably an equitable defense that argues that the plaintiff delayed unreasonably in asserting a claim, particularly in a way that would prejudice the defendant. So this is how Harjo loses the first case. What I want to do is start by asking a question about what equitable means in this context. So how do we think about equitable remedies? And there's some literature about this as already in terms of, you know, what are the racial implications of laches? I think there's also an undercurrent here in Ian Haney Lopez's really foundational book, White by Law, when he talks about the way that, for instance, the definition of Native nations that goes back very far is a way of disenfranchising Indigenous people. So I think this is a conversation that we're having about the disenfranchisement of Indigenous people, as well as what it means to be equitable in the context of law. So I want to ask this question: should a structurally marginalized group making a racism claim ever lose an intellectual property case on a claim of laches? And if so, what would that look like, and how would we think about it? I want to contrast that with TAM, right? When TAM ultimately becomes an obstacle to justice for Indigenous peoples in the context of Black Horse. So what does sua sponte mean? Well, it's an act of authority that is taken without prompting by another party. Now, I want to remind you that not only is Section 2A of the Lanham Act very old, but it is found to be constitutional in 1981, which is exactly as old as I am in Ray McGinley. So since 1981, courts had basically been saying, I mean, we decided this question, stare decisis, we don't need to revisit this. So what we end up with is a dissent in that case by Judge Laurie, who asks the same question that I ask in the book when I very briefly discuss this case, which is why now? Why does the court now decide is the time to brief this question of the First Amendment? And I have some answers to that question in the book, but I want to explore that in greater detail, right? Like why now, and what are the racial and temporal implications of that? So the question that I want to leave you with here, and then I will end with 3 other questions, is what does it mean to raise that question right now? What does it mean to raise that question in a context that creates a kind of divide and conquer politic between Asian Americans and Indigenous peoples in a way I would argue that's not really good for either group? And what does it mean when we have courts making sua sponte decisions that are contra to stare decisis? And in what ways do those hamstring the court and also create the conditions for racial injustice? So 3 questions that I want to end with. The first question is, how should we treat time as a racial justice issue? How does laches play out in Harjo and Black Horse? And also, how does sua sponte briefing play out in TAM? So I think these are the 3 questions that are going to center the paper that I am doing and thinking through, and I will end there.
Awesome. Thank you so much. So I have a question that came in from Megan Anstus. She says, an interesting study of time, but very US-centric. Does it hold up globally? What about in areas not as affected by European conquest?
I would argue there is nowhere that is really unaffected by European conquest, if only because the way that globalization operates and the way that international law has progressed is very much structured through colonialism and structured through what Cedric Robinson talks about as racial capitalism and what Nancy Leong talks about as racial capitalism. So that's the first thing I would say. The second thing is, so there's the chapter that I wrote in my book on post-raciality really interrogates the international. So it focuses on international intellectual property law. And one of the cases I want to point to that I think answers this question of why time is also important internationally is Golan versus Holder. Because what happens in Golan is that the United States is like, okay, now we are going to sort of pass the necessary legislation to comply with this copyright convention. But that has impacts for international creators all over the globe. So I think in a world in which the United States is a major player in intellectual property law, and those laws affect other countries, that is one way that there are international implications here. The United States waited a very long time to pass that implementing legislation. And so that is the temporal element. The third thing I would say is that I think that, I started by saying there's a lot to be interrogated here. And I think there are really important questions that could be asked at an international level about temporality and how it works. And my goal here is not to make definitive claims about temporality in all cases, except to say that temporality matters, and we should at least be thinking about questions of how temporality structures the procedural and substantive issues in the context of intellectual property.
Sweet. Awesome. Thank you so much.
I have a quick question. First, I think your project is amazingly cool. I'm also working on a time project, and maybe we can convince IDEA to have a time and IP as one of their symposiums, because I think it's really interesting. One of the things I thought of, and Golan is one of the, I've actually cited in Golan, but I really love that connection too. One of the thoughts is Henrietta Lacks and cells and the body. I'm wondering if you're thinking about, I know projects on time can just explode and be impossible to actually complete, but I thought about the relationship of control and time and cells, and Henrietta Lacks is such a good example of that. I'm curious what your thoughts were on that.
Yeah, I write about Henrietta Lacks in the second chapter of the book. I should probably know the chapters, but I don't. Somewhere in the book, there is some material about Henrietta Lacks. There's obviously a huge gap in the time between when her cell line is commercialized and when her family is able to intervene. And part of that is about information, right? It's about when her family gets information. So I think time questions also intersect with other structural questions about who has structural power and how social justice progresses. The thing I want to say to this, without getting too much into the weeds of Henrietta Lacks, is that what I'm really thinking about in the book is a nature-science distinction. And I think when we talk about nature and science in the context of patent law, that we're always talking about temporality, because there are, I think, there's a lot of baggage associated with traditional knowledge. And I think a lot of that baggage has to do with this notion of primitivism and human progress, and an inability for certain people to participate in human progress. And that is a question of personhood and creatorship, which is the approach that I take in the book. But I think it's also a question of temporality. So I guess I would answer that question by saying I think that Henrietta Lacks exists in a larger meta-narrative of nature and culture and expertise, and who we empower to be a creator. So I think that is an overlay that also structures time in the context of intellectual property. And I would love to hear more about the project that you are doing at some point. I think that would be great to think about that.
Yeah, I think it's great. I mean, all of the presentations so far are great. And again, we need a conversation, a summit on that, all of that. Time and IP would be awesome.
Okay, we had one more question that I think we're going to save till the end to keep everything on track for time.
Thank you.
Thank you so much. All right, so next up, so we have 2 presentations left. Next up, we have Ben Winters. Openish government laws, trade secret protections in open government request for criminal justice technologies worsens the disparate racial impact of the tools. Ben Winters works on researching and reforming how technology is used in the criminal justice system as an Equal Justice Works Fellow at the Electronic Privacy Information Center, EPIC. He graduated from the Cardozo School of Law, where he was the editor-in-chief of the Cardozo Journal of Equal Rights and Social Justice.
Hi, thanks for the introduction and for having me here. So yeah, that very long and cumbersome title is all to say that I'm talking about open government laws throughout the US and the disparate racial impact of criminal justice technologies, and basically how those two things are related and why it actually worsens the disparate impacts that some of these criminal justice technologies have. So to start out, the problem that we're dealing with. Criminal justice automated decision-making tools are used widely and have been demonstrated to have accuracy, opacity, and bias issues. They're used widely at different stages, which I'm going to get into in a minute. But as they're often developed or just contracted out by third-party private contractors, there are trade secret protections as well as various contractual clauses that often are claimed at trial and in open government requests, which prevent the public from knowing the critical details about what kind of goes into one of these tools, what it tries to determine, what the factors are, and how that might, risk people being over-incarcerated, over-policed, et cetera. This is obviously only one of the reasons for the lack of knowledge about the details of these tools. There's sort of a culture of non-transparency in government, as well as, especially in the criminal justice system and the tech industry. And this is really reflective of that. So just to start out, there are no shortage of these tools. I'm going to be mostly focusing on risk assessment algorithm tools at the pretrial level, as well as predictive policing tools, which are probably the ones you've heard about most. But just to sort of give you a view, because I really want to drive home how interrelated all of these are, because they're all part of the criminal justice system. And most of the time, they either get you into the criminal justice system and make sure, be the reason why you are over policed or arrested, or that you are shown to be a higher risk to the community and therefore given higher bail, worse sentencing, worse parole, etc. So at first here on the left is where we kind of start. And those are criminalizing algorithms, which is sort of what I'm talking about there, is algorithms that prevent people from getting jobs, that prevent people from getting benefits based on their biases and stuff like that. Predictive policing tools are generally sort of tools that use past arrest and offense data to help determine where policing resources are going to go. And so you could very easily imagine that becomes a self-fulfilling prophecy where if an over-policed community is over-policed, that's what's going to show the records of arrests and offenses, and they will continue to get over-policed. And those tend to be poor neighborhoods and majority-minority neighborhoods. Lastly here is the surveillance tools, and that is a really broad swath of things. So that is some private and some explicitly public. Private ones include things like the Ring doorbells that are owned by Amazon and have a lot of partnerships with police, facial recognition systems throughout cities, drones and helicopters at protests. We've seen a lot of that, especially this summer. And then the rest of the tools, they really differ, but they generally are actuarial tools that have a set of factors determinative that you kind of plug in factors and it puts an output. That output is generally whether, measuring the likelihood that someone's not going to appear at trial if it's used pre-trial, or what risk they give to the community, they pose to a community, which helps determine their decision. And a lot of my fellowship so far, and continues to be, is trying to get access to these tools at the open government level to be able to analyze them and see if there are maybe things that are proxies for race, because there have been tools that have shown to be that way. It's really hard to get a sort of clear view on them because every jurisdiction is different. Sometimes it's statewide, often it's just county, city, department-wide. But just to give you a little bit of an example, here are two different risk assessment tools. On the right, there's a pretrial one, and it's one of the most commonly used throughout the country. You can see the factors that they use. And you can imagine how, some of them would lead in the heavily biased criminal justice system, the policing system, the carceral state that we have in this country. These are inherently, have a sort of racist tone to it, even if they are not having any of these subjective factors. But on the left, this is one that's used in Idaho, the level of service inventory. It's used by the Department of Corrections. And you can see, you probably can't see too clearly, but I will write at length about it in my paper, about some of the factors that they're using to determine someone's risk. And think about what we're talking about when you're predicting someone's risk. But we're talking about attitude towards convention, attitudes towards supervision, things about your job, labor market, schools, peer interaction, et cetera. And so without going too deep into the different tools, those are just two examples of sort of these actuarial risk assessment tools. So the common problems with these tools, if I had to quickly separate them out, are the opacity, which is what I'm really focusing on here. And that includes who is the developer, what is the agency that is buying it, how much are they buying it for, and what is the training like? What is the purpose? What is their stated purpose and benchmarks for evaluation? Is it being validated? Validation in general is just sort of the concept that they are running statistical analysis after a tool has assessed risk, for example, and actually seeing if it did. And so the reason that a lot of you probably have heard of this is this ProPublica article in 2016, which came around the Loomis versus Wisconsin case that was declined to be heard in the Supreme Court in 2016. But basically, this article used an analysis to show that Black males were extremely more likely to be perceived as higher risk by these algorithms than their white counterparts. And when over time, they showed that those white counterparts actually did more offenses in the actual time that they said they would. And so, keep in mind that these biases are based on age, ethnicity, race, and socioeconomic status. If you go back really quick to this tool, you can see a lot of these have to do with socioeconomic status, job, ownership of phone and home, friendships, even an attitude towards supervision. And so what information do advocates want and how do they get them as of now? So the information that helps advocates out are generally the contract documents to figure out the factors that are considered in a given tool and see, to be able to get a hint at whether they are explicitly drawing on protected classes or more likely the proxies for protected classes, which is what some of those things that I just mentioned were. And validation studies, again, training materials, and use manuals. So a lot of this information really illuminates how a given entity is performing and using these tools. Are they determinative? Are they partially helpful? And it really, if you consider the stakes here, this type of information about algorithms that are used, or even just statistical analysis used in the criminal justice system to determine, these determinations that directly impact life and liberty, the innovation and other justifications for trade secrets, are a little bit weakened. So how do people find out these tools as of now? Big, well-resourced organizations or just people in general do a lot of requests on this, and they do a lot of appeal. There's very little proactive government disclosure, and it changes a lot. And so this goes to the barriers. These are picked up and dropped off very frequently by different agencies throughout the country. And it's really hard to get a good view on what jurisdictions are using what tools and how dangerous are they. And so the barriers, one of the biggest ones that I'm focusing on in this paper is the trade secret and commercial protective measures. that are in the federal FOIA statute, as well as pretty much all of the state analogs, although they vary a little bit. So I'm definitely not going to go into each state, but they vary a little bit, but almost exclusively, or almost always, have a trade secret or commercial protection exemption of trade secrets. And so generally speaking, trade secrets have to be only known to a limited group of people, and you basically have to want to keep it secret, in addition to the value that it creates, which is sort of obvious, and if you're selling it and contracting it out to governments, et cetera. And a lot of the justifications are just sort of philosophical in regards to if someone creates something, they should own it, and as well as competition and innovation. So these are examples of some of the roadblocks that you run into, that I personally ran into when sending out a lot of FOIA requests about risk assessment tools. In Mississippi, there was there's a policy where there's an extreme amount of deference by the agency to the contractor, and basically ask them if they're okay with handing over these documents. And most of the time, as you can imagine, they probably are not super willing to do that. It's become an industry, which is one of my main points that it should not be. On the federal level, here's a good example, just to show that what is exempted. Things that are trade secrets and commercial or financial information obtained from a person and privileged or confidential. And so when I requested the risk assessment information from the DC Pretrial Services Agency, this was one of the exemptions that they claimed. So on the federal level, and I'm not going to go into the state of the law at different states, but on the federal level, last year there was a Supreme Court decision, the Food Marketing Institute versus Argus, that lowered the level of scrutiny that a trade secret holder has to get over in order to successfully assert this trade secret protection and prevent disclosure. They actually took away a sort of long-standing precedent regarding substantial competitive harm and only left this part right here, that is where it's both customarily and actually treated as private by its owner and provided to the government under an assurance of privacy. And so you can imagine that you could very easily, as the contractor, make that argument. And for certain applications of government contracted work that directly impacts the life and liberty of individuals should be subject to scrutiny, should be able to be tested by independent organizations. And the fact that it is uniformly not is potentially really dangerous for communities and pretty much everyone that is constantly at risk to be entering into the criminal justice system and continue in this cycle that these algorithms exacerbate. So one thing I do want to say is that the biggest way that defendants that are subject to these tools are getting access to the tools when the contractor wants to assert these trade secret protections are protective orders. So you can basically see the factors, how it applies to you, but you are not allowed to say it to the public. And so it's really, that's sort of the one norm that has been identified, particularly by Rebecca Wexler, who had a great piece on trade secrets in the criminal justice system last year. And it really kind of brings us to this question about the interest between open government laws and, specifically at trial, evidentiary rules. It's exposed to the general public. And as I keep making the point, to the criminal justice system, from policing to parole, and the whole cycle in that is really a matter of public interest. And as we have all seen and known, but have very recently been reminded of, it is not a system that has been very transparent, very equitable, and a system that absolutely needs oversight. And so these are some of the values that I want to explore and to sort of help justify the argument that the policy argument that there should be minimized exemptions for applications that have such a high risk of damage and have been shown to have damage. So lastly, I want to just really drive home that This is it's reflective of a whole system. There's not a lot of transparency through the tech industry, and there's not a lot of transparency throughout the criminal justice system. The protections of this context just reflects this, and procurement policies, basically how agencies contract these developers and whatnot, really have to be changed in order to have higher standards in regards to transparency, in regards to validation studies, in regards to analyses of the potential biases, and continue all of that. So this can be done via legislation in regards to Public Records Act, but it really can be done by procurement regulations and just wanting to do it, frankly. So I know that is a lot, and in this specific topic, the tools differ so much from different places and are done by different contractors. And the laws, there's 50 different FOIA laws and then a 51st at the federal level. And so it's really hard to drill down on exactly that issue, but this is the issue that I'm exploring in my paper. Thanks.
Awesome. Thank you, Ben. All right. All right, so next up, we have our last presentation by Dr. Fadi Own, The Belated Awakening of the Public Sphere to Racist Branding and Racist Stereotypes and Trademarks. Dr. Fadi Own is a senior lecturer in law at the University of Sydney Law School and is admitted to practice law in New South Wales. He is a co-author of Intellectual Property, Commentary and Materials with Colin Bodkin and David Price. Fadi completed his doctoral thesis on the law, theory, and policy related to stigmatizing trademarks. A representative publication emerging from the work is Whitewashing Australia's History of Stigmatizing Trademarks and Commercial Imagery, published in Melbourne University Law Review, which has been shortlisted for the 2020 Australian Legal Research Awards. All right, you can go ahead and share your screen.
Thank you. Okay. Hopefully you can see that. First, I'd like to acknowledge the traditional owners of the land that the University of Sydney is built upon, the Gadigal people of the Eora Nation. I pay my respects to Aboriginal elders, past, present, and emerging, and I extend this respect to any other Indigenous people here with us today. I wish also to thank the organisers of the Race and IP conference and for inviting me to present my paper, which emerges from my doctoral thesis, which I submitted in 2015. As fate would have it, speaking to Dr. Vats' comment about chronopolitics, I had to submit this before Christmas. And as we know, the unbanked decision in TAM was handed down on the 22nd of December, 2015. We'll probably return to that in our discussion. The transformative Black Lives Matter social justice movement has shone a harsh light on endemic structural racism in Western civil societies, especially as it relates to police brutality and the hegemonic perceptions of oppressed minorities. A small but important consequence of this powerful movement is the long overdue mobilization of the contemporary public sphere against long-standing racist branding and racist stereotypes in trademarks. This encouraging outcome, exemplified by the archetypal intergenerational Native American struggles against the Washington football team's suite of marks and similar battles across the Atlantic and in the Antipodes, is due in large part to the sustained efforts of diverse minority groups in drawing to the attention of the broader public the societal problem of racist trademarks. Mercifully, it seems that these days, racist trademarks, irrespective of their authorship, are especially striking, and their own embodiment for provoking critical responses in equal measure. Xenophobic commercial signs, as we know, operate as odious communicative vectors, resonating far beyond their traditional roles in the market economy as mere signifiers of merchant goods / services, or as a species of private property. Such commercial signs reinforce, promulgate, and even shape racist stereotypes. My paper today delves into historical trademark registers with a view to setting out some of the very harmful racist tropes circulating as registered trademarks in the transatlantic and trans-Pacific public sphere, as well as charting both their stubborn resilience and the almost autochthonous resistance to such marks by marginalised, that is, counter-public groups in these jurisdictions. Building on relevant trademark jurisprudence and normative models of deliberative democracy, and standing on the shoulders of giants such as Jürgen Habermas, Nancy Fraser, Rosemary Coombe, and Patricia Loughlin, I make the case that challenging racist commercial insignia and the racist tropes embodied therein is in the democratic public interest. It is worth noting that though federal trademark law in the United States and Australia and trademark law in the United Kingdom all emerge from similar foundations, their paths with respect to the registrability of racist trademarks have recently diverged. The post-Mattel and Tam epoch, for example, forecloses the contributions of US trademark law in this space and once more speaks to the law's general valorization of free speech and proprietary concerns. Yet, in the United Kingdom and Australia, both common law liberal democracies without constitutionally entrenched rights to free speech, trademark law still offers some emancipatory potential for those railing against racist commercial symbols. I don't have the time to discuss this potential today, but let me say that the law here always seems ready to disappoint us. Consider, for example, the prohibition against scandalous or immoral trademarks set out in the Trademarks Acts displayed before you. There were, of course, earlier prohibitions on objectionable marks in some of these jurisdictions. Indeed, many were in Australia in the colonial times of the 1870s. But I use these acts here, and the 1905 acts, that is, as a useful point of comparison. As we will see, these provisions and its early iterations, and indeed subsequent iterations, did not prevent the registration of racist marks. So, a word of warning, many of the following trademarks are deeply disturbing. After much careful consideration and reflection, I've chosen, however, not to show the most disturbing trademarks that I've come across in my archival research. For example, marks that celebrate racialized violence, murder, or other forms of bigoted vulgarity. The historical archives reveal many racist tropes and stereotypes, far too many to discuss here, but by way of a potted discussion, there are trademarks that engage racialized discourse structured by binary oppositions, such as the racist trope juxtaposing black and whiteness as manifest in soap and cleaning products. You may be familiar with the infamous Fairbank Company's device mark depicted before you. This trademark was registered in all Australian colonies and later in the Commonwealth Trademark Register, as well as in the UK, as well as achieving federal trademark registration in the United States. Imagine that, these ID circulating across, this racist ID circulating across the public sphere generally. There are countless tropes which engage symbols in the form of what's before you, as for disinfectant products and so on. There are countless instances of minstrel or sambo type trademarks, such as those depicted before you. As you see, the one on the left is a minstrel character who's supposedly stropping a razor upon the tail of a horse. That's taken from the US archives. To the right is a minstrel character reflected in the United Kingdom archives. Further instances of minstrelsy and indeed samba imagery are evident before your eyes there. There were also racist trademarks extolling the colour fastness of blacking and dyes. These horrendous marks that are before you, and I've taken one from each jurisdiction, United States, the United Kingdom, and indeed Australia, on the bottom right-hand corner, which itself later was registered in the United Kingdom. These horrendous marks, and indeed others, such as Harris's black but beautiful device mark, as depicted in the next slide, circulated widely in transatlantic and transpacific commercial and societal spheres. There are outrageous marks, such as that before you. Others, which celebrate icons of servitude, the contented enslaved persons, mammy figures, etc. As we know, Aunt Jemima has recently been retired, but let me say, on my research, there were countless aunts that were made manifest in the US, Australian and UK archives, especially in the early 1900s. Here is another example of so-called topsy. An image on the right shows the registration of this mark for cigarettes in the United States. And before then, there was in colonial New South Wales, a refusal to register that very same mark, not because it was considered offensive or racist, but because someone had got in earlier and registered the same mark. Again, pecuniary concerns predominate here, not the interests of people. This idea of servitude was so embedded in, it seems, the Australian sphere that there was a trademark which remained on the register until the 1940s, celebrating enslavement, such as the blacker lacquer stove polish. There were other minority groups who were the subject of racist trademark representations, such as the Oriental Other. I'm thinking here of Edward Said's famous work, Orientalism, and there are some examples of the so-called lustful Turk with his odalisque. To the right, you have a UK registration of an American trademark, Eva. And again, there are far too many to mention here. There are anti-Asian trademarks drawn from the UK archives, such as this before you. Many instances of so-called Chinese rat catchers. Again, I haven't shown the worst of them, but some images in the advertising demonstrate or depict so-called Chinese persons swallowing rats as part of their attempt to collect rats. Rough and Rats here is one such trademark which evokes that imagery. There's an Australian registered trademark, which, if you're interested in further, is set out in my article in 2019. Of course, one group which suffered greatly at the hands of this cultural misrepresentation and misappropriation, slurs and commodification were Indigenous Americans or Native Americans. Here are some terrible instances where, and disrespect shown in the bottom right-hand corner for the misuse of headdress sacred objects, pressed into service of, it seems, footwear. There are racial slurs depicted in many types of classes, especially in the tobacco class of goods or services. You have other instances which rely on stereotypical representations of Indigenous Americans, the violent so-called Indian, the subservient, ready to please Indigenous woman, as reflected in Landale Lake's Mia, which has, as we know, recently been retired. There is one of the original trademark registrations in the bottom right-hand corner. So, the point to be made here is that the historical record has shown that the law, somewhat regrettably, cannot or will not offer a full answer to those seeking truly egalitarian and vibrant democratic civil societies. In other words, in addition to whatever available legal course of action may be enlivened, multiple and disparate avenues for pursuing this public interest are necessary, such as via protest, educational campaigns, boycotts, shelter activism, and so on. It is these kinds of sustained counter-public energies that lay the necessary groundwork that ultimately force the demise of time-honoured, stereotypically racist trademarks such as Aunt Jemima, Uncle Ben, Land O'Lakes, Mia, and of course the Washington football team's abandoned moniker. Admittedly, the decisive trigger for this long sought-after change had nothing to do with trademark law. It was more to do with nervous brand owners seeking to rid themselves of their racist marks following the aftermath of George Floyd's senseless custodial murder. In other words, perhaps somewhat cynically, these advancements did not arise from what the Greeks would call a metanoia, a general repentance by brand owners, but rather were motivated by monetary or pecuniary concerns. It is somewhat remarkable that it took such a seismic event, and indeed its reverberations across the world, to coerce the discontinuation of racist commercial imagery. Despite these recent machinations, it would be wrong to think that this resistance is new. It's always been there. It's just that such voices, at times voices in the wilderness, can no longer safely be ignored. The normative framework of my paper suggests then that meaningful normative and empirical pressure in the public sphere can build over time before culminating a real change. The vehicle by which this change is realised is via Nancy Fraser's conception of subaltern counterpublics and its subsequent telling impact on Habermasian public sphere theory. Nancy Fraser, informed by Spivak and of course Rita Felsky, coins the term subaltern counterpublics, which she defines as parallel discursive arenas where members of subordinated social groups invent and circulate counter-discourses to formulate oppositional interpretations of their identities, interests, and needs. Sometimes this counter-discourse means that counterpublics employ culture-jammed versions of the very racist marks that they have been rallying against, such as what is before you here. These efforts, as reflected most famously in Scene magazine's cover juxtaposing blackface minstrelsy and the Cleveland team's former mascot, are very powerful. But by far, the most powerful work has been that of Susan Shown Harjo, a proud Navajo and Haldolgi Muskogee social justice advocate. Thus, it is apposite that the final words go to her in her recent lecture at the Pediati Distinguished Lecture Series earlier this year. She says, thank you to everyone who wants to be part of the quest for justice. I'm paraphrasing. For everyone else, we'll see you on the long road. Let us hope that the citizenry in modern democratic societies continue to mobilize in favor of the former and that those on the long road shrink in number. Thank you.
All right, does anyone have any questions? You can post them in the Q&A or in the chat. All right, so that was our last presentation. Thank you everyone for joining in, and thank you to all of our presenters. I'm now going to open it up for questions. I have a few questions that came in along the way I can ask now. So if the presenters could stay on, anyone else that wants to ask any additional questions? So Calvin Hewitt asked, from who invented, oh, I think this was to our third presenter. This was for Dr. Anjali Vats. So from who invented the cotton gin to Elvis, to Ali G, to Kim Kardashian, in the photo she looks like Beyonce, and digital blackface, appropriation is old. My question is what is the change being sought? Changes in the laws, reparations?
I think that question might be for Professor McLean.
Okay, yeah. Sorry, Professor McLean, did you want me to read that question again?
No, I heard it. I think it's not so much. So with the Prada case, she used Instagram, the woman who brought it to the world's attention, and it ended up creating a panel of people to sit at the table and advise Prada on the kinds of imagery to go into its fashion. As I mentioned, scholarships for underrepresented students in the fashion industry and internships. I think it's those kinds of restorative justice kinds of things that I think have more sway than use of reparations. I mean, the problem is, to whom are you going to give money, right? I think it's more of wanting a seat at the table and being consulted or being mentioned, that we took inspiration from whatever culture is being targeted. The collaboration, consultation, those are the things that are being asked for. And as opposed to trying to use the law, and as Dr. Aoun just mentioned, here in the US, we no longer have trademark law that will suppress marks that are disparaging or immoral. And so I think you have to be more creative in order to effectuate change.
All right, the next question was for Dr. Townsend Gard. Megan Anstus asks, what are people doing to address the issues once they are pointed out?
Well, good question. We're not sure. So we've been addressing industry directly about the questions that we're finding. But I don't know. I mean, I think a lot of soul searching, I think on the Facebook groups where quilting is happening, at least, a lot of fighting, a lot of unfriending, a lot of soul searching. And I don't know if Whitney has anything to add to it, but I think it's an interesting moment, an interesting cultural moment of self-reflection that needs to happen across the board. I guess the other part I would say is that, what's going to happen. So right now people are sort of like, oh, we should hire someone African-American to come teach for us. And I always say, great. What about in 2021 and 2022? And this is not it's not a fad. And so that's my biggest concern. I don't know, Whitney, if you have anything to add.
Yeah, I think I would definitely add that well, for me at least, something that the last presenter said that really stood out to me is that this isn't a metanoia. The fact that, you know, something so horrendous had to happen to even effectuate any kind of change is what's truly disturbing. And if you think about the quilting industry and just at the base of the fabrics that you see, when you see kids on fabric, they're white. When you see any type of person on fabric, they're white. And I think that even translates, like, to me, a personal story is that, like, my house was the house of Black Santas because my mom was not going to have white Santas on our Christmas tree because we're a Black family, and it was so hard for her to find. And I think that, like, our struggle answering this question still is that nothing's really being done to change this and be more inclusive, especially within the quilting world, because industries believe that their base is white. And even in the fashion industry, they believe their base is white. And I talk about models and how brands want to be represented, and they don't want to be represented by a diverse crowd because of what hegemony tells us is the norm or what is popular.
Awesome. Okay, so next up, our question is for Fadi. I understand your dismissiveness of brands that are making changes and abandoning racist marks. It's about money, not repentance. There seems to be some evidence that consumers, especially younger consumers, are holding brands to a higher ethical standard and asking them to take stands on important issues. Without sounding too much like a brand apologist, are you cynical all the way down about corporations, or do you think there is a chance of social movements actually nudging some brands towards taking real responsibility and doing real work on diversity, inclusion, even if it doesn't always serve their bottom line?
Yep, thank you. Excellent question. I suppose much of my cynicism was made evident in my short talk, but I do think for those, for groups that have been oppressed for millennia, centuries, any form of reconciliation in the form of discontinuance of vectors of harm are to be welcomed. So that is to be appreciated. But what motivates that is not necessarily, I think, a respect for the human dignity that is inherent in the other person. It's more to do, I think, with the bottom line. You know, historically, as was the case, minority groups could be ignored because commercially they represented in the views of the brand owners an insignificant line or contribution to the profits. That is no longer the case. Social media and other forms of counter-public communication has in many ways balanced the communicative ledger. There's now scope for things to go viral and for people to be held account to the messages they send out. In my doctoral thesis, I talk about the fact that marginalized groups were always railing against this misrepresentation. In Australia, for example, Indigenous Australians formed various progressive associations, such as the Aboriginal Progressives Movement and so on. And in their claim to be awarded citizens' rights, would you mind? Citizens' rights, because up until 1967, Indigenous Australians who've been on this land for over 60,000 years weren't counted in the reckoning of the Australian census as citizens. 1967. But in the 1920s and 30s, in the manifesto to claim citizens' rights, one of the things they pointed towards was, in fact, to stop being represented as what's called the Jackie stereotype, which is the Australian equivalent of sandbag imagery. So in light of contextual oppression, it meant that much to those social justice advocates to actually mention that. brand owners just ignored them, of course, then, but they started to take heed now, which is a good thing. The greater problem, which I don't think we have time to discuss, is this so-called issue of reclamation. And I'd like to, there's so many questions I want to ask each of the panelists, and perhaps when the thing ends, we can continue our conversation offline. But for example, Professor McLean and Dr. Chatmon, in the fashion industry, do we have instances where even the make of clothes doesn't accommodate different groups? Is it so inherent there? Or Dr. Vats, you talk of laches, and this will agonize me in many ways, sort of dissuaded me from attending the first Race and IP Symposium, which had Simon Tam from the Slants. I as a form of civic protest, I decided not to go to that, but I went to the Race and IP conference in New York last year. What a year it's been. But his point about reclamation, which I think I find is somewhat unconvincing when you look at the mythology of the Wikipedia entries that have been updated over time. But to go to the point, this question of laches that you raised earlier, what about the other equitable maxims? Those who come to equity must have clean hands, and so these are all difficult issues which, perhaps we can discuss later. But yeah, so to get back to the point, yes, well, thank you, brand owners, for coming to the table. You're a couple of 100 years a bit late. You've done untold damage, but we at least recognize your contribution in 2020.
Great. All right. So then this last question I have in is open to everyone, and it is from Loretta Brady. What type of ethical decision frame is useful in scaling inclusion insight, which is apparently very hard to earn based on the examples today, based on your collective insight today?
So I get this question a lot, right? Like the policy question, like what do we do about this? I think is a question that is always on people's minds, because I think that we have a discomfort with merely identifying racism, like that's not doing something. So I want to say two things here. One about that idea, right? Like is identifying doing something, and then also about what maybe the more tangible, upscalable remedies are. So the first thing I would say is, I want to remind us that Derek Bell, when he was writing as a critical race theorist, was like, part of the problem here is in the inability to see racism when it happens. And so I think that the first step in whatever race project we're doing in the context of intellectual property requires seeing, right? To use a potentially problematic metaphor, but to be able to perceive in some way how race is operating and how it is structuring different spaces. So I think part of the work that's happening right now is about that. It's like, okay, we have all of this space of IP, and we're really just starting to uncover all the spaces that race exists. So I think that's the first thing. The second thing I would say is, I have been thinking about this as a question of where, of different levels of intervention. So the last chapter in my book is about what I call IP fugitivity, and it draws on the work of Fred Moten, Black Studies scholar Fred Moten. And fugitivity, takes us back to fugitive slave laws, but it also forces us to think about resistance and Stephen Best's work about how IP actually comes out of fugitive slave laws to some extent. So there's all these questions of like, how do we intervene? And there are four things I want to highlight here. One is ethics. So part of the project of identifying where race exists in IP is a question of ethics. How do we realign our ethics in a way that is racially equitable and inclusive in the context of IP? The second thing I would say, and I like the example of Prince here, the time when Prince wrote slave on his face. That's a performative intervention, right? So what can we do as individuals with the spaces that we occupy to performatively push back against race in the context of intellectual property? And maybe that's a protest against the Washington football team, right? Maybe it is public pressure at a time when that public pressure is legible to people. So that's the second thing I would say is upscalable. The third thing I think that we want to think about are lawyers, right? How do we teach our lawyers to practice differently? And the ethics and the performance has to inform that, right? We have to rethink how we teach our lawyers. I was at a panel on race and reparations, and one of the things they were talking about is how, there are these really race, these texts about the music industry that don't actually talk about where race exists and where racism exists. So this is a question of redesigning curriculums and teaching lawyers in a completely different way. And then the last thing I'll say is, the last thing to me is the policy, is the legislation, because we have to get a sense of where we are and where the leverage points are, I think, before we can start overhauling policy. And for as much as, I have fantasies of burning it down, I don't think that's either practical or likely. So, how do we think about incremental change in a way then that can be built into legislation? And I'll end by saying, I just want to, remind us that intellectual property maximalism, which historically is a double-edged sword for people of color, mostly not very good though, that historically is bipartisan. And so we have to really change the public language about this in both parties.
What she said.
Awesome. I think that's all we have. Thanks again for all the great presentations, and thanks to everyone for joining in.